In 2006, a jury convicted Deering of arson and 5 counts of felony murder for the 5 children who died in the fire. But an investigation launched by the newly elected Oakland County District Attorney Karen McDonald found the DA who prosecuted the case committed grave misconduct by withholding critical evidence from the defense, relied on jailhouse informant testimony, and fire analysis that has since been debunked as junk science. I'm pleased to have Oakland County District Attorney Karen McDonald with me tonight. Karen, welcome to the show.
Thank you for having me.
Now, you were just elected district attorney in 2020 and received the initial request to look over Mr. Deering's case by an innocence clinic at the University of Michigan Law School. What was it about this case that you found so compelling?
You know, I'd like to take credit for launching an investigation just on a hunch, but actually I was asked to look at the fire science only. As many of you know, the science has changed, and so the Innocence Clinic and the Innocence Project have really focused on a lot of convictions that were due to arson science. In doing so, 2 assistant prosecutors in my office who have been there for years and years and years approached me and said they had some grave concerns about the case, separate and apart from the arson science. And so I just ordered the file to my office, and it was 3 boxes of files. And we soon discovered that there was an issue, and that's because Juwan Deering was convicted based on 2 things: the testimony by the arson expert, who, by the way, was never challenged in any way by his attorney, and he didn't have his own expert. And the second thing was the testimony of 3 jailhouse informants who all testified that, together with all their statements, it was considered a confession. So we ordered the file and immediately discovered that there were internal memos and notes indicating that one of those informants did indeed receive many deviations and dismissals on his own charges due to his help with this case. The fire was in 2000. He wasn't tried and convicted until 2006. So as many of your viewers know, jailhouse informants are admissible. You're allowed to use a jailhouse informant, but you have to tell the jury what, if anything, they received for their testimony, because we want to know what their motive is, and is there a motive, and that sheds light on their credibility. So after seeing something that was very concerning, I immediately ordered all of the files our office had on all 3 of those informants over the span of many years, and it was, I can't say anything else except devastating, because it was clear, very clear, that those 3 informants, all of them had received deviations and charge amendments and sometimes outright dismissals based on their help with this case. And the only way you would know is if you had access to the confidential files of the prosecutor, because they were handwritten notes and internal memos indicating that. So that started a large effort to, what do we do next? Which is, I was very transparent. I called the Innocence Clinic lawyer up and immediately asked for a special prosecutor and an investigation, which occurred, and then it just got worse. Actually, this case was always just getting worse. I did forget to mention the problem with this too is the assistant prosecutor at the time who was trying the case said to the jury, and so did the detectives, and so did the informants, I received nothing, I was promised nothing, I expect nothing. And that is just, yeah.
So, okay,
so then there's a whole other terrible part that I can go into if you'd like. Yes, yeah.
So besides the lies that were told from the witness stand, it seems like there was a lot of evidence that was obviously withheld from the defense. What was exchanged during discovery? What did the defense know?
Well, through the independent investigation, we discovered that there was one child, the oldest child who survived the fire, and he was interviewed within a couple weeks of the fire. We had a VHS tape in our file of the interview. That child, who's now an adult, did not testify at the trial. What we discovered, though, is that we only had in possession the first half of that interview. The second half was withheld from what we can tell our office, and for sure, for certain, the defense attorney and Mr. Deering, and it showed the child being presented with a photo lineup and pointing to a picture in the left-hand corner saying it wasn't him, it's not the voice I heard, it's not the car, that's not the Juwan. We didn't even have a photo lineup. We then found from the sheriff's department the photo lineup, and Juwan Deering was in the bottom left-hand corner. So it's just glaring exculpatory evidence that was never turned over. So there was really just no other conclusion other than, and I consulted with a lot of people, because since the very beginning of this case, the moment those two lawyers came to me, I always wanted there to be a good explanation. And I was always hoping it wasn't what it looked like. And not only was it always what it looked like, it was just worse. So, he, I can say with 100% certainty, Mr. Deering did not receive a fair trial. And once that conviction was vacated by the judge, we then had to really try to look at it with fresh eyes. I convened a panel of law enforcement, prosecutors, and there was just nothing there to charge him. So he was released.
So speaking of that, so you noted that in 2000, the prosecutor's office had denied warrants 3 times before Deering was actually charged. The former prosecutor, David Gorseca, said he wasn't aware prior warrants had been denied, suggesting that had he known, then this would have probably played out different. Why would that be a fact that he or any prosecutor would know? Because as a former prosecutor, whenever I adopted a case from a prosecutor that may have left or went to a different unit, there was always this file and with notes that would get the prosecutor up to speed. So why is this something that he didn't know?
So David Gorseca I actually contacted him before I made this public. I felt that was a courteous and professional thing to do. A lot of people have asked that question, and you as a former prosecutor know this. The elected official does not get briefed on what a prosecutor is saying to a jury, or how many times a case is. Sometimes it's not just denied. It's actually what we call furthered, meaning we want more investigation. And 3 separate assistant prosecutors looked at that and spent a lot of time on it and said they just didn't think there was enough there. So it was a denial, and I'm not sure, but protocol would be that the elected official would be notified that a prosecutor didn't think that there was enough there. However, remember, the fire took place in 2000. These informants, they continued to add to their investigation with Jailhouse Informants. So when it was charged, it was presented to him as, we think these are credible informants. We think that it's solid, and 5 children died, and we're going to go forward. And I, having been in this role for 9 months, I just, I think people don't understand that there's over 100 lawyers, over 200 people in the office. You don't get briefed on that kind of thing. And honestly, the jury believed the credibility of those informants, and nobody disclosed to the former elected official, or actually anyone, that they had received these deals. And they received deals on a lot of cases that wouldn't ever come up to the prosecutor. In fact, the really difficult thing, well, actually, there's just not one difficult thing, there's lots of them. But many of the assistant prosecutors who are still there, their notes are in those files. And they made those amendments and deviations because that either that prosecutor came to them or those detectives. They had no idea that 4 years later, they would lie to the jury about that. So I have to say, I'm a former judge, I'm a former private practice attorney, and I'm a former assistant prosecutor. And this has by far been the most troubling thing of my career, just to really process that this anchor that you connect with on a daily basis as a prosecutor or a district attorney, that your law enforcement is credible. It's been very unnerving for my entire office.
I bet. Well, definitely glad that you took another look at this case. I'm sure that Derek is appreciative of that as well. Thank you so much for your time and for coming on. Oakland County District Attorney Karen McDonald, again, thank you so much.